So welcome everybody to the CPD on the amendments to the Wills Act that took effect earlier this year. We have our presenter, Will Steinberg. He is a senior policy analyst at the Department of Justice. He received his call to the Manitoba Bar in 2015 and is a graduate of Queen's University. Shout out to Queen's University. And the University of Manitoba's Faculty of Law, where he received his JD. His professional experience includes work for Legal Aid Manitoba, the Centre for Human Rights Research, the Public Interest Law Centre, and Human Rights Commissions of Manitoba and Yukon. In his current role, he leads the development of legislation across a range of topics, including wills and estates and family law. So he's quite experienced and had his hand in these amendments as well. And with that, I will turn it over to Will to discuss those amendments.
Thanks very much for the introduction, Arthur. Good afternoon, everyone. It's a pleasure to be meeting with you today to speak about the Wills Act amendments. As many of you know, these came into force on May 1st of this year, so pretty recently. Some of you may already have questions about particular changes or what the implications of these amendments are. So hopefully we'll answer all of those questions today. I'll just note that if you do have questions after the presentation, I encourage you to contact me by email or phone, and I'll provide my contact information. I also wanted to just mention that I had hoped to include a copy of this PowerPoint presentation in the links for the presentation, but unfortunately I wasn't able to do that because I didn't have the permissions. But I do have another link that I provided, which is an information document which summarizes what's in this report. And that's specifically made for lawyers, so hopefully that will be useful to you. There's also an information document for the general public, which might be useful for sharing with clients. There will be time reserved for questions at the end of the presentation. But if you do have a quick question, please feel free to enter it in the chat box, and Arthur will kindly stop me so that I can provide an answer for you. So on your screen here, you'll see an outline of the presentation. First of all, I'm going to speak a little bit about the purpose and design of the amendments. I'll just really briefly run over that. And I will be moving on then to changes to the formal requirements for making a valid will. From there, I'll go on to provisions involving spouses, and I'll try to give some examples that illustrate how those provisions would work. From there, I'll move on to the remedial provisions. Those are new powers which will be given to courts to correct common errors. And I will hopefully, time allowing, have some case law from other jurisdictions where those provisions have been used that I can share with you. From there, I'll talk about the wills registry and international wills. I'll note a few of the transitional provisions, and then we'll move on to questions. So purpose and design of these amendments, I'm just going to skim over this in the interest of time. But basically, Yukon's Act was created in the 1950s, and there was no substantial amendments to the Act since then. So as you can imagine, over time, there's quite a gap that's developed between Yukon's Act and similar legislation in other jurisdictions. So it was really overdue to update Yukon's Act in a way that would make it similar to what's in place across Canada, and also to take advantage of some of the lessons that have been learned in other jurisdictions. So the changes are designed to give better protections against fraud and undue influence, reflects changes to modern day relationships and how those relationships change over time, new powers for courts, and those are the main changes. And in doing those, we've tried to ensure that these new provisions will be uniform with what is in place across Canada. So most of these come from recommendations from the Uniform Law Conference of Canada or legislation in BC and Alberta especially. So I'll move straight into changes to the formal requirements for making a valid will. There are a couple of main changes that you'll want to know about, and there will also be a few more technical changes that I'll just mention so that you're aware of them. The main changes are changes to the requirements for witnesses to a will. There are a couple of changes there, and the other main change is that there is a change to the rule for the placement of a testator's signature. So I'll explain those in some detail. But just to mention some of the more technical changes, Section 9.01 has been added, and that one extends the witness beneficiary rule to people that sign on behalf of a testator at their direction. So witness beneficiary rule is that a gift in a will to a person who is a witness to that will is automatically voided. That's to prevent coercion, and that has been extended now to include those people who sign on behalf of a testator under their direction. So in situations where the testator is not able to sign themselves because of, say, a physical disability. The other technical change is that the definition of spouse has been added to the Act. This definition will include common law spouses, meaning couples that have cohabitated for a year or more. And I'll describe that a bit more when I get to provisions that apply to spouses. And lastly, there was a restructuring of the exceptions for infant wills. So will makers who are minors and are in the RCMP, Canadian Forces, or sailors at sea. So those are just some of the technical changes, but getting back to the main changes for the formal requirements. The biggest one that you'll want to note is that there's a witness capacity requirement which has been added. So that's in subsection 102 of section 5, and it states that the witness must be 19 years of age or older and have mental capacity to be a witness. Secondly, a person who signs on behalf of a testator cannot also act as a witness in that same will. So there are some exclusions for witnesses that you'll want to pay attention to as you're helping your clients. So just to explain how the capacity requirement works, you may be wondering what it means to have mental capacity to act as a witness. So this is not something which is defined in the Act, and there's not a test that's set out in the Act, but it's a provision which has been in place in Alberta for some time. And based on guidance from Alberta, this requirement only relates to the person's capacity as a witness, so to act in that role. That they must be able to state that they saw the testator, sign the will, or be capable of acknowledging the testator's signature. Next, the rules for placement of the signature. These were in section 6, so section 6 has been replaced. Formerly, section 6 was kind of a hard rule that stated that improper placement may invalidate a will altogether, or also that any gifts or directions which come after the signature of the testator are automatically excluded. So that's been adjusted slightly to a presumption. The way that the presumption works is that an improper placement would not render a will invalid in all cases, and that a gift or direction that is in time or in location in the document itself after the signature is presumed not to be part of the will. There is some guidance from the Legal Education Society of Alberta that explains how this would work in practice. Basically, signing the will other than at the end would not render it invalid. And the testator, the will would be valid if it appears that the testator intended to give effect to the will by the signature, even though it may not be at the end of the document. However, there's a presumption that the testator did not intend to give effect to anything which comes below the signature. And that means that as a presumption, it's rebuttable, and someone who may be a beneficiary would have to apply to court in order to provide evidence of the testator's intention to make that gift to them in order for that gift to be completed. Moving on to changes involving spouses. There are three main changes that you'll want to be aware of, and I'll go over each here. So as I mentioned, definition of spouse was added. The other major change is that automatic revocation upon marriage has been repealed, and automatic revocation of gifts and appointments to a former spouse has been added. So I'll explain how each of these would work. So the definition of spouse would include common law spouses. The term applies within the act to gifts to a witness or a person signing on behalf of a testator. So those people or their spouses, any gift to them would become invalid automatically. There are new provisions which would allow those void gifts to be saved by the court, and I'll get to those later. But the change in the term spouse means that those automatic voidings of gifts to them would apply also to common law spouses. The other major change, automatic revocation upon marriage, that is now repealed. So formerly, when a person wrote a will before marriage, at the time that they became married, that will would automatically become invalid unless it was made in contemplation of the marriage, or there was something in the will which stated a direction otherwise. So now that it's repealed, if a person has a will and they become married, their marriage will have no effect on the status of the will. And I say that also wanting to note that that change in status wouldn't affect them on entry into those relationships, but a change in their marital status to exit a marriage would have an impact on their will. And that impact comes from automatic revocation of gifts to a former spouse. So I have a couple of examples which I wanted to give to just demonstrate how this would work. The first example is if an unmarried person makes a will and then they marry. So let's say that a couple is living common law and one of them makes a will which benefits their common law spouse. If they were to marry, then at this point, that marriage would not affect the will. So any gifts to that spouse would still be in place. Formerly, that marriage would have invalidated the will. So that has changed. Another example is, let's say that a married person makes a will and then they divorce and they marry a different person. Because marriage no longer affects the will, if they had a will in that first marriage, it actually continues even past the time that they've married a new spouse. So the separation from the first spouse would lead to automatic changes in their will, and I'll get to those next, and then I'll revisit this example. So the next major change is in section 10.01, revocation of gifts. So this is something which is in place in other jurisdictions, including Alberta and BC. And basically the way it works is that unless the will directs otherwise, any gifts or appointments to a former spouse would be revoked after the relationship is terminated. When that happens, the will would be read as if that spouse had predeceased the testator. The important time in these cases is the time of the testator's death and not the time that the testator made the will. So if the testator's separation is still in place when the testator dies, then that's the point that the automatic revocation would take place. I'd also note that this automatic change only applies if the will doesn't direct otherwise, and it will only apply to wills that are made after the amendments come into force, so after May 1st, 2021. Just a moment here. So I'll just return to the example of a person who made a will during a marriage and then divorces and remarries, just to illustrate how this change would take place. Under the previous version of the Act, the will made in their first marriage would automatically be revoked when they married another person. Once it's revoked, if a new will isn't created, then intestate rules would apply. So in situations where you have a testator who is older and in their previous relationship they had children, that would lead to a situation where children of that first marriage may not inherit in the way that that original will had intended. Under the current version, the original will would continue to be valid after the testator remarries, and any gifts or directions in that original will to the first spouse would be revoked. So if that will also contain gifts to children of that first marriage, those would continue. And if it included any gifts to the former spouse, those would be treated as if that former spouse had died before the testator. And those would likely be passed on to the children or however else the will directs. So the important thing to note is that if a relationship ends, those wills will continue in that way unless something is done in order to terminate that will or a new will is written. The main question you might be asking right now is how you would know that a relationship has terminated. And in subsection 2, it explains the situations that amount to a termination. And those would be a grant of divorce, a declaration that the marriage is invalid, or a separation of 12 continuous months or longer without a reasonable prospect of resumption of cohabitation. So each of those would trigger the automatic revocation of gifts if the will doesn't state otherwise. You may also wonder what happens in a situation where spouses separate and the will is in place, but then they reconcile. And if that separation has been for more than a year, but then they reconcile, does that mean that the automatic revocation of gifts would still apply? And actually, it would not. So subsection 3 includes an exclusion for spouses that reconcile after a termination of their relationship. And this goes back to the relevant time being the time that the testator died. So if the spouses had historically separated and then they become spouses again, whether they do that as married spouses or as common law, as long as they're spouses at the time that the testator died, then the automatic revocation would not apply in that situation. So moving on to the remedial provisions. As I mentioned, there are a lot of new court powers. These will be in sections 30 to 34. The main powers that are introduced here are a saving provision for gifts that are automatically voided. So those situations where the witness beneficiary rule would void a gift, those can be saved under section 33. Another main change is that the court will have the power to validate a will that does not comply with all of the formal requirements. So whether it doesn't meet the requirements for a will itself, or an alteration to a will, or a revocation of a will, each of those situations, if they don't meet the formal requirements, then the court can treat them as valid despite that failure. That would involve an application to the court, and any application would have to be made within 6 months of the grant of probate. The other power is that courts will be able to correct errors through rectification and restoration powers, and I'll explain those in some more detail later. The other type of remedial provision is in section 15, which deals with lapsed and void gifts. So section 15 was in the former version of the Act, but it was slightly different. It had placed any lapsed or void gifts automatically into the residue of the estate. And we've replaced that with a system of priorities for distribution. I'll just note a couple of things before I get into how that distribution would work under section 15. First of all, these remedial provisions would apply to all wills, regardless of whether they were made before or after the amendments came into force. And as I mentioned, those applications to the court would have to be made within 6 months of the date of granting the probate, but the court may grant an extension. So distribution of lapsed or failed gifts. A lapsed gift is usually a situation where the intended beneficiary can't receive the gift because they've died. That's the most common example. In those cases, what would happen with the gift? Formerly, it would go straight into residue, but under this new system, it in principle goes according to what the wishes of the testator would be. So there are a few steps that you would run through to determine where the gift would land. First of all, if there's an alternate beneficiary named in the will, it would go to that person. And that would happen whether it fails for a reason that's noted in the will or for any reason. If that doesn't apply, then it would go to the descendants of the intended beneficiary if that intended beneficiary is a sibling or child or other issue of the deceased intended beneficiary. So I'll give an example in a moment, but moving on to the next step. If neither of those apply, then it would go to the residuary beneficiaries, if any are named. And if none of those apply, then it would follow the intestate succession rules. So to give an example, let's say that my will states that I give to my brother Bob $10,000. And if Bob can't receive that gift because he's living in China, then it would go to my friend Alice. And let's say also that the will has a provision for residue, that it gives the residue to C's charity. In this example, you have an intended beneficiary who is a sibling, an alternate beneficiary, you have a reason that the gift may fail, and you have a residuary clause. So if Bob had died before me, the gift would go to Alice, who's the alternate beneficiary. And that would happen even if Bob had come back from China or whatever reason that the gift may have failed doesn't apply, it would still go to Alice. If Alice happened to also be dead, it would go to Bob's children because Bob is my brother, and as a sibling, descendants of the intended beneficiary would go to that person's, as a sibling who's an intended beneficiary, it would go to that person's descendants. But it's passed on in a way that, just to go back for a second, it's passed on as if the deceased beneficiary died intestate without a spouse. So let's say that my brother Bob had died, but he had a surviving wife. If it went to Bob's children, none would go to the wife because it passes as if they died intestate with no spouse. In none of these cases would it go to Alice's children because that intended beneficiary is not a sibling or issue. Now, if Alice and Bob were both dead and they had no children, then it would go into the residuary clause and it would go to C's charity. But let's say that C's charity does not exist any longer, then the intestate rules would apply. So that's a lot of different scenarios, but I think hopefully it illustrates the point for you. I'll move on now to the powers that are provided for courts. The first of these is the saving provision for void gifts. This would apply to gifts to witnesses or people who sign on the testator's behalf and their spouses. The court may allow these gifts despite them being automatically voided if there's clear and convincing evidence that there was no undue influence by that beneficiary or their spouse, and that the testator intended to make the gift to the person. Sections 30 and 31 are sometimes they're called the dispensing provisions, and these are the provisions which allow the court to validate wills that are not meeting all of the formal requirements. So section 30 deals with wills that are not compliant or a revocation that's not compliant, and section 31 deals with alterations or revivals that are not compliant. These provisions are very similar to provisions that are in place in other jurisdictions and have been for some time. So just below on this slide, you'll see a table where it includes similar provisions in other jurisdictions and how similar Yukon's provision is to these jurisdictions. So the provision that we've added here is almost identical to what is in place in Alberta, and it's very similar to what's in place in BC. In this next slide, I've included the specific wording of these sections so that you can see it, but also so that you can see that it includes the test that the court would apply in order to validate these non-compliant wills or alterations, etc. So in section 30, a will or a revocation of a will that does not meet all the requirements can still be accepted as valid if the court determines that the document or the change reflects the final testimony intentions of the testator based on clear and convincing evidence. And similarly, in section 31, there must be clear and convincing evidence that the change reflects the testimony intentions. So I'll move on to some examples of how courts have interpreted these provisions in other jurisdictions. I'll describe a few cases, but just to summarize the main points from those cases. The main issue in each of these cases has been whether there's persuasive evidence that the change was intended to be the final testimony direction. In these cases, they've also found that evidence from outside of the will itself can be admissible. That's described as extrinsic evidence, and I'll explain what that means and its role in a moment. But the other key point from these cases is that the threshold for the courts to use these powers is quite high. So instructions alone, instructions that may be given to a lawyer, say, those are not enough to convince the court that it should exercise this power. I see there's a question here. Okay, if it's all right, I'll come back to this question a little later. So there is some guidance from the BC's Probate and Estate Practice Manual, which really breaks down these key issues that the courts will be looking at and the test that will be applied. The main one is the court will ask, does the item represent the testator's fixed and final intentions for disposition of their property on death? It's also been determined that the court's role is not to look at the validity of the instrument, but whether it represents the person's final intentions. As I mentioned, extrinsic evidence can be admitted, and extrinsic evidence basically means circumstances surrounding a document's creation and statements of the deceased that would indicate what their intentions were. Alberta's Act specifically allows this, this type of evidence to be admissible, but BC's Act is silent on whether it's admissible or not. And similarly, Yukon's Act doesn't explicitly say that extrinsic evidence is admissible, but there is a BC Court of Appeal decision which ruled that extrinsic evidence is admissible. So likely that would be the case in Yukon as well. Just a couple of cases that I'll go over quickly here. An important one from BC is Young Estate, and in that case, that's the case in BC which sets out the general test for alterations to a will. And it dealt with whether a handwritten document giving directions for certain dispositions demonstrated an intention to amend a will. So could those written notes be used in order to give instructions to change the will, and those be treated as a valid change? In that case, the court first looked at whether the document was authentic, and then it moved on to the test that I mentioned about the fixed and final intentions. They also looked at context-specific factors that may be included when they look at whether there is a fixed and final intention to do with this instrument or document. And some of those are listed there. Things like signature, whether it's in their own handwriting, whether it included funeral arrangements and specific bequests, and also the title of the document. In this slide, I've just listed a few of the main cases on dispensing provisions. These mainly deal with instructions that were outside of a will and tried to be used in order to make a change to the will and treat that as valid. So I won't go through these too much, but there were a couple of interesting cases that I'll mention from BC. There's Mace Estate, and in that case, a document that was not witnessed properly was treated as a codicil, and that was done in order to avoid intestacy. And then in Horton and Bruce, the draft will was signed by the will maker, the draft will signed by the will maker was held as valid only for the purpose of invoking its revocation clause. And I just included these cases here because they demonstrate the ways that the court may look at clear intentions and use these powers in order to make whatever changes are necessary to make the valid change. Moving on to the rectification power. This is found in section 32. It's something which is adopted from Alberta, and it allows the court to correct errors that are due to an accidental slip, omission, or misdescription, or a misunderstanding or failure to give effect to instructions by a person who prepared the will. So in here, there's basically a grab bag of different accidents that can happen with a will, common errors. And in a case where the court is satisfied that the will does not reflect the testimony intentions, then they can intervene in order to correct the error. The main question you probably have is whether or what exactly an accidental slip, omission, or misdescription are. As I mentioned, this has been in place in Alberta for some time, and there are not a lot of cases, but a couple that speak to what these things are. So in Riri, there was an error by a solicitor's assistant, which made an incorrect distribution to the testator's grandchildren. And using extrinsic evidence, it was clear the intention was a different distribution, so the court was able to correct that error. In Fuchs and Fuchs, there was another example where they used rectification, kind of a strange example where a couple made a will following a marriage, but the marriage turned out to be an invalid marriage, and then they remarried, and remarriage ended up voiding their will because in Alberta, marriage would void a will. And the court rectified that by adding a clause in the will to confirm that it was made in contemplation of the marriage. So another question you may be asking is, what if the omission involves the testator's signature? So the signature is obviously pretty key to a document being a will. And what happens if there is no signature or there's a major problem with the signature? So this is explained in subsection 2 of the section. And it sets a higher threshold for this type of error. It says that the court can only validate a will that is not signed if there's clear evidence that the testator intended to sign the document as their will, and that failure to sign it was due to pure mistake or inadvertence. This has come up in some cases in Alberta. None of the cases have been successful. I'll just explain some of those, but they demonstrate basically that when it comes to an error involving the signature, this power is construed very narrowly by the courts, and there's a very high threshold for adding in a signature. So these are some of the cases where signatures were not put on a will and how the court dealt with that situation. In each of these cases, there was a draft will prepared by a lawyer, and it was sent to the person to sign, but unfortunately, the person died before they signed the will. So hopefully that's not something which ever happens to any of you, but if it does, these cases might provide some guidance. In none of those cases, the court decided to put in the signature and validate the will. So again, it's a very high threshold. Moving on to restoration power. So this is a power which allows the court to restore original words in a will that have been damaged by a writing or a marking or obliteration that makes them illegible. In a situation where you have a direction in a will and it's been covered by a marking or something, there's a couple ways that could be dealt with. You might treat it as an invalid amendment to a will, and those could be saved using other court powers. So if it's not a valid alteration, or if it can't be validated using other sections of the Act, this is where restoration power would apply. And how is the power used? Well, if an invalid alteration can't be validated, and if the court is satisfied that making a change would reflect the testator's wishes based on evidence, then there are certain things that it can do. So if an alteration, marking, obliteration, etc., made part of a will ineligible, or pardon me, made it illegible, and it's not validated, the court may try to find the original words that are under the marking or obliteration and restore those words. And it can use any means it would like in order to find out what those original words were. So some explanation from Legal Education Society of Alberta. And they say it better than I can, so I'll just read it here. An obliteration occurs where the words are cut out, painted, or inked over, or otherwise completely illegible. The court can use any means to decipher the original words and give effect to those words, but only when the court is unsuccessful in discovering the words will an unattested obliteration stand. So that covers the powers for making corrections to a will. And now I'll move on to registry of wills and international wills. There's not a lot to say about the registry of wills. A section was added that would enable a registry to be created. But at this point, there's not a registry that is being created in the regulations now. So that's something which may happen in the future, but it's not something which is happening at this point. Moving on to international wills. Section 36 and the schedule to the Act are added, and these ratify the International Convention, providing uniform law on the form of an international will. So this is an international agreement that basically allows a will to be effective in any signatory state. So any state that's ratified this convention, the will will be legally valid in any of those. I'll just note that this international convention will come into force in Yukon on January 6, 2022. How does it work? Well, if a will is made according to the requirements of the convention, it's valid in any state that has ratified the convention. For each of you, this might be important if you have clients that have property in another country, and it's a country which is a signatory to the convention. Signatories to the convention include 20 US states, which include Alaska, and also the District of Columbia. And in this slide, I've included each of the countries that are currently signatories to that convention. So the list, if you wanted to consult it, is on the website for the International Convention on Wills. And I can provide that for you if you would like later. But this might be useful, for example, if you have a client that has property in Alaska or another American state. I'm just noting a few of the requirements that there are for an international will, because it would be slightly different from a will that would be made under the normal rules. So it can't be a disposition of more than one person, must be in writing, and can be in any language. A very important one here is that it must be signed in the presence of at least 2 witnesses and an authorized person. So an authorized person under the convention is a member of the Law Society of Yukon or a lawyer in another jurisdiction, but it does not include notaries. And signatures must be at the end of the will, signatures for each of those people. It also must include a certificate, which is attached at the end of the will, signed by an authorized person, attesting that the requirements and procedures for drafting and execution of an international will have been satisfied. So next, I'll just highlight the main transitional provisions. The key one here is section 37, a will that was made in compliance with the Act before the amendments come into force cannot become invalid because of the amendments. You will probably want to know about revocation of gifts and how that applies with the transition. So just to explain some of that, revocation of gifts to a former spouse only applies to wills that are made after May 1st, 2021, when the amendments come into force. If a will is canceled because of a marriage, it can't be revived by the amendments. So if you have a situation where revocation on marriage applied simply because these amendments have been created and that provision is revoked, it doesn't mean that those wills which were terminated now are valid again. If a will was canceled before the amendments come into force and is revived, that's sort of a tricky situation. If a will that was made before the amendments come into force is revived after the amendments come into force, it's treated as a will that was made before the amendments come into force, if you follow me. Basically, it's still a will that was made before the amendments came into force. So gifts to a former spouse would not be revoked in those cases. And also, just to note, the remedial provisions apply to all wills, whether they were made before or after the amendments come into force. I'm just summarizing this slide, a few of the points which I thought might be key for each of you. Unless the will states otherwise, there would be no cancellation of a will because of a marriage. Revocation of gifts to a spouse if the relationship terminates will take place for wills that are made after the amendments come into force, unless those wills contain statements directing otherwise. Gifts that fail will not automatically go into residue as they used to, and witnesses to a will must be mentally capable, over 19, and neither they nor their spouse should sign on the testator's behalf. I'm just going to check the time here. Okay, we're getting quite late, so I'm sorry about that. I'll skip straight to questions. And I see there was a question here. So the question is, what if the clause said, if Bob survives me by 30 days, I give him $10,000? Is this a sufficient contrary intention to avoid the gift going to his children? I have to think about that for a moment. Oh, and another comment. Will the Estate Administration Act be amended to treat common law spouses the same as married spouses in an intestacy? So at this point, there are no plans to make that change to the Estate Administration Act. So it will remain the same. I think that's an excellent point, though, that it makes sense that that act would also change. But at this point, I just can't confirm that that's going to happen. But returning to the earlier question, Bob survives me by 30 days. Yeah, I have to admit, it's not a question that I can answer here. I have to give that some thought. So if it's all right, I'd like to get back to you on that question. I apologize, I'm not able to answer it here. Are there any other questions?
Well, if nothing else, you have Will's information up there on the screen. You feel free to contact him if any further questions come up as it percolates a little bit in our minds. I want to thank Will for his thorough presentation on the amendments, pointing out every hiccup that could arise. Very useful, I think. And I hope everyone else has a wonderful day. If that's going to be it, if no more questions pop up in the meantime, going once, going twice. All right, I guess we're all done for today then.
Well, thanks very much, everyone. And as I said, if you still have questions, please feel free to contact me. And I will try to answer that question that was posed. Anyways, have a good day, everyone. Thanks a lot.